Oh, welcome to Case Briefs with Megan. Let's make this case brief. As we know, families are messy. However, this family in Garratt versus Dailey dares to ask the question, would you still sue me if I were a 5-year-old? Before we get into this case, we need to break down what the crime is here that we're talking about, and we're talking about the crime called battery. It is usually paired up with assault. So when somebody says that they're being arrested for assault and battery, assault is that fear or that apprehension that you are going to be, for instance, touched in some way, like punched or something like that. Battery is the actual act of punching. But let's break this one down a little bit. How exactly a crime is broken down to see if it checks all the boxes varies state by state. However, for the very basic kind of overall sense of what makes a battery, we look at 4 elements. We are looking at intentional, do you know that you're about to do the act that you're doing? Touching, and by touching we mean punching, hitting, smacking of another person, because it's not battery if you hit yourself, in an offensive or some type of manner that you know that other person is not going to like. So if we put it all together, essentially you need to know that the act or the touch that you are about to put on another person is going to be harmful or offensive to them. The thing with Garratt versus Dailey is that intent really comes up here in this case, and let me tell you why. The person bringing these charges is a woman named Ruth Garratt. Ruth Garratt has a sister named Naomi, and Naomi has a young son named Brian. Brian's last name is Dailey. Does that sound familiar? Because that's the person that's being charged in this case. And just as a quick heads-up reminder, Brian is 5 years old at the time this all happened. Naomi and Brian come to visit Ruth for whatever reason, as families do. Naomi and Ruth are chatting it up in the backyard. Brian is 5 years old, so he is running and doing little kid things, I don't know, running around in a circle or something like that, whatever kids do. At some point, Naomi and Ruth are chatting it up and they're not sitting down, and Brian goes over to the chair that his aunt was sitting in. He picks up the chair and he puts it down a few feet away, and he sits himself down in it because he's 5 years old and he wants to sit in a chair. Then Naomi go to sit down where they had apparently been sitting before. Ruth doesn't see that the chair that she had been sitting in has now been moved a few feet over. She falls back and she ends up actually breaking her hip. During what is apparently the slowest fall back ever, Brian sees what's happening. He gets out of the chair and he's trying to move it back over underneath his aunt. But again, to emphasize, he is a toddler, so he's not very good at moving things, so he doesn't make it in time. Aunt breaks her. Ruth, being the best aunt in the world and now having this fractured hip that she's got to pay a lot of money for, decides she's going to sue her 5-year-old nephew because she contends that Brian intended to take the chair from her while she was about to sit down in a very mean-spirited act. Now the court here at hand has this really big question, which is, can a 5-year-old show that they intended to hurt somebody, and can it be shown in this exact case? Here's the deal. Remember, intent is part of that crime that is battery, and according to the court, this is a direct quote, whether you are 5 or 55, you must have done something wrong before we can hold you liable. What the court here does is that they gave the very basic lawyer answer of, it depends. It essentially says, look, if we had evidence that Brian saw that you were about to sit in that chair and then immediately took it as you were sitting down, you might be able to have some sort of realization that he had the intent to take the chair from out underneath Aunt Ruth while she was about to sit down. That's mean-spirited. That constitutes battery. We've got all of the other elements here, right? We've got the touching, even though it is kind of not really, since it's just a chair being pulled out from underneath, but law's not perfect. We also have the harmful or offensive act, which has now caused his aunt to break her hip. And we also have the fact that Brian has done this to his aunt, to another person. Courts say, look, you don't even have to know that this act is going to cause somebody pain. You just know that there has to be a substantial certainty, is what they say in this case. The court says, look, essentially what we know is that Brian moved the chair, his aunt tried to sit down later, and the chair wasn't there. We don't know if Brian knew that him moving the chair would maybe cause his aunt to sit down in the exact spot where the chair was, and that would cause her harm. Emphasis, he is 5. He even says, look, even the absence of the intent, even if it's like he didn't want to cause a prank or cause her any harm, that wouldn't absolve him of this if he knew that something like this could happen. Courts say, without any further evidence of seeing what Brian knew and didn't know at that time, we don't have enough evidence to find one way or the other. We've got to remand this case down to a lower court to see if they can figure out what Brian knows. Learned anything from this case? Please don't bring 5-year-olds to court. All of the law students will read this case in their first torts class.